Welcome to the panel discussion on international property law, scholarship, and pedagogy in times of COVID-19 pandemic. I want to thank all the audience who have joined us from near and afar. And I also want to thank the Center for Social Critiques of Law at the Kent Law School and the International Society for the History and Theory of Intellectual Property hosting this event. And I also want to thank the panelists for taking part in their busy schedule. So I'll give a very brief introduction to why we thought this event would be timely and necessary, and then I'll introduce a couple of housekeeping points. IP law and scholarship are rarely in public spotlight. Since the outbreak of the current pandemic, however, the political and social effects of IP legal rules have become much more apparent and especially crystallized in the issue of the so-called TRIPS waiver. The last time when public media had covered the clash of IP rights with public interest so extensively was during the AIDS crisis and the South African government's decision to allow generic production of patented high-cost AIDS drugs without the patent holder's permission. We know that thanks to AIDS activists, the lawsuit by pharmaceutical subsidiaries against the South African government was withdrawn. Currently, there is a similar disagreement between the current global IP structure and global public interest and opinion, about which IP scholars themselves are divided. The main focus of the contention has been the TRIPS waiver, which proposes to temporarily suspend TRIPS obligations for the duration of the pandemic for the member states. In my opinion, the disagreement, however, goes deeper and poses questions about the role of legal scholarship and pedagogy, especially in IP law. These involve fundamental questions about our understandings of law, either along formalist, historical, theoretical, interdisciplinary, and/or socio-legal points of views. And in this context, about scholarly approaches about the function and purpose of IP law and its social effects. My interest is to what degree IP scholarship is implicated in the justification of the current status quo, as well as whether its dominant formalist and doctrinal methodology is not epistemologically neutral, but already has inherent political implications. And I'm sure that my co-panelists have more to say about this. Now, how we will proceed, I'll introduce each speaker and they will share their thoughts about the state of IP scholarship for about 5 minutes. Then I hope that there will be a more organic discussion where I would invite panelists to comment on points raised by other panelists if they wish to do so. And I would also invite the audience to raise their hand if they wish to pose a question, or alternatively share their question in the chat box and I will pick them up and read them aloud. The order of panelists who will give us their views is first Dr. Luke McDonagh, then Professor Fiona Macmillan, then Professor Graham Dutfield, Dr. Aisling McMahon, then Dr. Els Torreele, and Professor Alain Pottage. I will introduce them individually. So we'll start out with Dr. Luke McDonagh. And Dr. Luke McDonagh is an assistant professor of law at the London School of Economics, where he teaches intellectual property and constitutional law. And I hand the voice or the mic over to him.
Thank you, Hyo, and it's really great to see so many familiar faces in the audience and also familiar names. Also some people that I don't know. So, this is really an opportunity for us to reflect, as Hyo said, on what this current crisis means for our field of scholarship. And I think that that is a particularly important question right now because this debate over the TRIPS waiver is, in my view, the most important international intellectual property issue for a generation. There are 100 countries, mostly in the global south, that are calling for a waiver of intellectual property obligations under the TRIPS agreement. We as IP scholars, particularly those of us who are based in the West, have a duty to respond. And yet, as my first point, I must say that until recently, I was somewhat baffled as to why so few IP academics had written on this topic or had spoken about it. I am very glad to see that more commentary is coming out and more events are taking place almost daily now on this topic, which is really great. But I do remain troubled about why this took so long. And given that the proposal came out in October 2020, I think it's fair to say that academics in the field of health law and of course activists working on the ground have been far more engaged than we have in wrestling with the key questions here. And so I do wonder within our field of IP whether we have created a silo around patent law in particular that tends to overemphasize the technical complexity of patents and obscures their political context. And this brings me to my second and third points, which are linked. I am concerned about the uncritical assumptions in our field, namely, number one, that patents are neutral and not political, which I believe Fiona is going to comment on as well. And also the idea that patents only create positive incentives for innovation. And I think that I myself, in my scholarship and teaching, I've not always given enough attention to the way these assumptions operate. And the nature of a global crisis, such as the one we currently face, is that it brings into the open profound problems and schisms that might otherwise be hidden. And so to explain this in more detail, I want to talk about the assumption that patents are technical, neutral property objects and not political, when we know that these are state-granted rights or state-recognized rights that are offered pursuant to public objectives. And the political nature of patents is apparent to those of us who remember the 1990s birth of the WTO and the HIV/AIDS crisis. But there's no doubt that during the period from the mid-2000s until the COVID period, the political character of patents was subsumed somewhat by the technocratic elements therein. But the vaccine inequity crisis has taught us what we should have been much more clear about, I suppose, in our scholarship, which is that there's no way to see IP and the wider TRIPS agreement without understanding its place within the global political economy. Some national jurisdictions make the political character of patents much more evident, as we saw with the US Supreme Court decision just last week in Arthrex about the fact that patents require executive political oversight in the United States. So overall, the COVID crisis reveals something that many of us did know, but perhaps didn't speak it up enough about, that patents have always been political and have real world impacts. And it is wrong to view patents as neutral, that we need to assess them in their layered effects in society and in the economy. So we have a lot of work to do here, but it is a challenge that we also must rise to if we're serious about our scholarship. And my final point is that I'm also troubled that there's a trend in patent scholarship that sees patents as only offering positive incentives. I mentioned this earlier. So to dwell for just 1 minute on what I mean by this is that this is often presented, particularly at the moment by opponents of the waiver, as an a priori truth that is given without even a footnote or explanation, that patents create positive incentives for innovation. And yet, if anything, the past year has seen unprecedented state intervention in the vaccine market. And a lot of success of the vaccines is down to this coordinating state intervention and huge public funding of vaccines, which many of which are based on health technologies developed at public institutions like Oxford or the US National Institutes of Health. It is simply not the case that the market and the patent system was left to its own devices and we got the vaccines as a result. The Japan Times recently reported that in Japan, where unlike the US or UK, the private market and private companies were largely left alone to conduct R&D in this area over the last 18 months, there has been a comparative failure to produce a usable vaccine in 2021. So the assumption of waiver opponents that if we achieve a waiver text, this will lessen the incentives for innovation needs to be unpacked and critiqued. We need much more detailed analysis on this. We need to investigate the ways in which patents can create negative and even perverse incentives. We know from comments to investors that the Pfizer CEO has already said that the monopoly pricing power they hold will enable them to charge $150 to $175 for booster doses to rich countries. And if you consider that production remains limited, this creates the incentive to sell those rather than first doses to poor countries. We have to look at AbbVie, a pharma company that has managed to obtain patents on Humira for 39 years. And which spends more than 10 times on stock buybacks and dividends than it does on R&D. So the idea that patents only create positive incentives really must be questioned. And the idea that if we weaken the patent protection internationally through the waiver, that in the next pandemic, pharma companies will not come to our rescue, which is a kind of rhetoric I have heard at some of these events. This is not a ringing endorsement of the status quo. It's actually a damning indictment, an indication of how much power such companies wield. So we must, as scholars, be willing to question our own assumptions. And I'll leave you with that point and just say thank you all for listening. And I hope that you engage with me and with the other panelists on this.
That's great. Thank you so much, Luke. And thank you for giving us a really good overview of the state of the discussion about the TRIPS waiver more generally, but also about the IP scholars' responses to the so-called TRIPS waiver proposal. I would like to hand over the video or the mic to Professor Fiona Macmillan, who is a Corporation of London Professor of Law at Birkbeck School of Law, University of London, as well as a professor at University Romattre and University of Technology in Sydney. She has conducted extensive and far-reaching research in the areas of intellectual property, cultural property, and international economic law. So the floor is yours, Fiona.
Thank you so much, Hyo, for that very generous introduction. How to start and how to say something useful in 5 minutes. Luke's introduction was great, and I'll try and build upon it a bit. I want to, in fact, it's going to take me about 6 minutes. I apologize in advance, but I want to start with 3 observations about methodology. The first one is, in any academic discipline, the methodology that is used to study something transforms the object under observation. Second observation is that choice of methodology is, however, pre-scientific, and this means that it's conditioned by what you want to find out about the object under observation. And what you want to find out about the object under observation is a pre-methodological political choice. So another way of saying this is choice of methodology is always political. I'll say in a minute why I'm saying this. And the third introductory observation is that the long tradition of Western philosophy that I choose to use in this moment tells us that although politics and ethics are separate, political choices inescapably involve ethical choices. Into this little schema of truisms, I want to add some observations on the value of interdisciplinarity in legal research. What does it mean to study law from an interdisciplinary perspective? Okay, I can't possibly answer that now, so I'm ducking out of it, and I want to turn the question around and ask instead, what could it mean to say that we're not studying law from an interdisciplinary perspective? And to put my pre-scientific cards on the table here, I'm asking this question because I think it goes to the heart of a larger question that concerns us today, which is why there has been so little activism amongst legal academics and IP academics specifically around the issue of patents over pharmaceuticals. Positivist scholars, or black letter scholars, we call them, often claim to eschew interdisciplinary perspectives. They say their only concern is to work out what the law, as revealed in the primary legal sources, is and how secondary legal sources might aid that interpretation, as we all know. But the law is not some divinely conferred and unchangeable artifact. Judges know this. When they're trying to work out what the law is, they interpret it purposively. They ask, what did the legislature intend the law to be? What did the legislature intend the law to do? So what are we as scholars? Are we just judges of judges? Is our only role to work out how the judges did their job and whether they did it well? Okay, I think to do positivist research of this type is already to adopt a pre-scientific political position that assumes that what the legislature intended is ethically correct, and that the link between that ethical position and the operation of the law is empirically valid. If positivist and avowedly non-interdisciplinary legal scholarship involves refusing to question the politics and ethics of the law, then that is always and already a political and ethical choice. Some types of positivist research does form an important basis upon which we can conclude that the law is producing perverse results, that it's not serving the political or what we often call policy choices that informed its adoption. And this, of course, relates to the question of the relationship between the political choice and the means employed by the law to realize it. It's a useful strategy to point to these types of contradictions, but it should not and cannot absolve us from considering the ethical validity of the founding political choices. And if we're going to consider the ethical validity of those founding political choices, then we've already arrived at an analysis of the political economy of law. And once we start to talk about the political economy of law, we are interdisciplinary. The methodology of political economy, as it's applied to the study of law, necessarily involves close historical analysis of its development and of its political, social, economic, and cultural choices and effects. Okay, so in the last minute, let's turn back to the question of the political and ethical choices that are embodied in the law around the patenting of pharmaceuticals as we see it working in the context of the current pandemic and the debate around access. For argument's sake, putting the pro-patent, or what I want to call the I'm not questioning the political choices of the patent system position, in its most favorable light, this is the apparent choice we're looking at, Either we let lots, and I mean lots, of people suffer and die now, or we undermine the efficacy of a system that will, in the future, produce life-saving and life-enhancing pharmaceutical products. But spinning this, and that is a spin, spinning this into a choice between the present and the future gets us precisely nowhere. To understand the choice like this, in that sense, is not only to grossly oversimplify, but it's also to buy into a normative claim about the future without investigation. And Luke already said something about this. What the choice involved in this, shall we let people die now, or shall we negatively affect the production of pharmaceuticals in the future choice? What this apparent choice actually is an empirically verifiable factual claim about death and suffering in the present, posed against a normative claim that the patent system is indispensable for the production of pharmaceutical products that will alleviate death and suffering in the future. We should, of course, never hesitate to investigate the accuracy of apparent factual claims. But the point that I really want to make here is that interdisciplinary perspectives are essential in allowing us to investigate normative claims. The normative claim that the patent system, undiluted by any even temporary waivers, is essential for the production of life-saving vaccines and medicines in the future is one that we can scrutinize using a range of interdisciplinary perspectives, including those, there's so much to say about this, but including those that come from history of science, science and technology studies, political economy, geography, post-colonial theory, and so on. After carrying out this interdisciplinary scrutiny, we may find that the debate is premised on a false dichotomy between two positions, which I think is the case here. And or we may find that there are still problematic political and ethical choices to make. I think also the case here. What, as scholars, we cannot do is to refuse to face the fact that there are political and ethical choices by pretending they don't exist. Thanks very much, Hyo.
Thank you so much, Fiona. I think you nailed the, well, you hit the nail on the head by linking the methodological choices that we think we are not making, but we do make, and the implications of those in our own scholarship and the practical effects that they have. So thank you very much, Fiona. I hope that we can return to many of the points later in the discussion. Now, Professor Graham Dutfield, who is a professor of international governance at the School of Law at University of Leeds, will talk, and he has far-reaching policy experience and also has published very widely on intellectual property law and how it interacts with sustainable development, health, bioprospecting, trade law, among many other things. And Graham has also just published a book on the history of pharmaceutical patents. So Graham, I can't see you, but please feel free to talk.
Hi, I'm sort of in the dark here, maybe, and the lights all weird. I'm sorry about this, but I am here. Honestly, I am here. Okay, please stop me at 5 minutes. This is completely rambling and incoherent. So if you're expecting something as good as Luke and Fiona's presentation, you won't get it with me. It's going to be all over the place. But I thought perhaps I'll be slightly anecdotal. I mean, how did I? I mean, I really shouldn't be a law professor. I have no degrees in law. I went to 2 classes in law in my whole life. One was by David Waiver, the other was by Michael Spence. So I guess they're very good lecturers. So I went to 1 class each. How did I got into this through a completely accidental, and but it's worth mentioning this because it actually reflects how I teach and how I sort of write and why I write what I do and how I think it sort of helps. So, you know, policy engagement was there before IP, and it all starts off with me getting a master's degree and looking for a job. And I had the amazing fortune to be taken on by a chap called Darryl Posey, and Darryl's experience was quite extraordinary. He was not just he was an academic. He wasn't just overworked and underpaid. He was overworked and unpaid. His money, he just had to just go around actually begging for money to do the work he wanted to do. Literally, you know, I'm not joking. And you know, it's what he had, he shared with me. It was like, it was, you know, cash in hand. He was affiliated with Oxford. Oxford didn't give him a penny. They almost never did, except for a little bit of teaching he did. And so Darryl was an entomologist, went to do his PhD research. He went to the Amazon, and while he was there, he made and he joined an academic institution called the Emilio Gualdi Museum in Belém in the Amazon, and he set up this project called the SciencesPo project. And what he did was he interviewed with the SciencesPo people about their land use, and he found out, he's one of the first people to discover that lots of areas of the Amazon are anthropogenic landscapes. They are managed and cultivated by the local indigenous people. And unlike his colleagues who were working with him, he thought this is politically extremely powerful, right? Because just as with Australia, terra nullius, the Marwa decision, if you are improving land, if you are doing more than just surviving in a hostile environment and adapting yourself to the environment rather than adapting the environment to yourself, it's very hard to challenge politically your a situation of landlessness, of being treated as primitive people, living in a state of nature. So his research helped to overturn this idea. So he took Amazonian people with him to a science conference. He said, look, they're scientists. They don't have PhDs, they don't have degrees, but they are scientists. And while he was there, they said, can you come with us to the World Bank to ask them not to lend money to build dams in the Amazon? And the World Bank decided not to lend money to Brazil. He went back to Brazil and was put in prison briefly. He's arrested. And then he hired me because he was one of the first people to say, well, this knowledge is extremely valuable. It needs to be rewarded, to be respected. And so he was a strong advocate of scientific engagement with his peoples as a relationship of equals and of mutual respect. So I came to work for him. So for me, I worked for him. He was my mentor, and I learnt that IP is inherently political in the most powerful way. And since then, I've been lucky enough to be an academic, but I've always been involved. And of course, COVID now is the latest massive crisis, but we have been here before, AIDS, HIV/AIDS, and lesser crises. For example, the fact that waiver was captured by business interests. There was a draft treaty to harmonize the patent law globally, the patent law treaty. Dysfunction was a technical cooperation, which is about really protecting first world assets in the third, rather than helping developing countries to actually grow their economies. And I've been involved in all of these things, including several others. For me, if anybody can learn from what I'm saying here, I learned myself through this amazing journey how political IP is. If patents are for 20 years, or for 25 years, or for 15 years, lives are at stake. Right. If copyright law is for life plus 50 or life plus 70, that again has massive implications for learning, for education, for scholarship, for culture, the scope of limitation exceptions, etc., etc. Where you have trademarks not just on words and logos, but also on the shapes and colors of medicines. This matters. Again, it matters in terms of access to product. So it's inherently political, absolutely inherently political. I'm not going to be holier than thou. People just want to live in an ivory tower. It's absolutely fine by me. I don't have a problem with it. It's okay. If you just want to do scholarship for its own sake, I also believe in scholarship for its own sake too. So not everyone should have the stance that I have. But let me just say, finally, I'm sure I must be near to 5 minutes, and I tend to ramble, so I do need discipline sometimes. I'm told to keep to the limit. But I want to echo what Fiona says about interdisciplinarity. I'm interdisciplinary by almost by mistake. Years ago, I actually applied to do the University of London LLM. I was rejected, so I thought that law was closed to me. Weirdly, the same academic year, 2 lecturers at SOAS asked me to be external examiner of 2 other dissertations of students on the course that I had been rejected, which is quite hilarious now when I think about it now. So I had no choice to always be an outsider in law, and I go to conferences in history, in economics, etc., 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 and I'm always an outsider. Outside of my comfort zone, which I now love to be in. I don't know what it's like to be in a comfort zone. And so I like being an outsider. But let me tell you for teaching, because you did ask me about teaching, about pedagogy. I don't tell students what to think. I'm not particularly opinionated in class. But what I do is I give them a perspective that is inside and outside of the law. And when you look at IP from all these different facets, all these different directions, that is the education that I think I'm giving the students. And then it's up to them to come to their own conclusions. Okay, thanks.
Thank you very much, Graham. That was really fascinating. I would love to hear more later about how you think that the more, I guess, the more practical experience of how IP affects real life, really, how that also informs your way of teaching and the research that you choose to do. So I hope we can get back to that. Thank you. I would like to invite Dr. Aisling McMahon, who is an assistant professor of law in Maynooth University, to speak. And she is a specialist in medical and intellectual property law with special interest in regulation of emerging biotechnologies and the relationship between intellectual property and bioethical concerns relating to health-related technologies. So Aisling, the floor is yours.
Thanks very much, Hyo, for that introduction. And it's great to be here today and have this conversation around intellectual property. I suppose as someone who is, my own research is situated both within intellectual property and also within the health contexts. So I'm coming at this from that perspective as somebody who works within both of those fields or areas. And one thing that I've been noticing, I suppose, as others have already mentioned, is this disconnect that's evident within our discipline, but also across even the legal discipline, in terms of how, as an IP lawyer or as a health lawyer, depending on which hat I wear, I might address the conversation. And this is one of the things I wanted to reflect on today, and to think about, or to say something about the disconnect, as I see it, evident between the patent and the health contexts, and specifically around how patents can have quite a significant impact on access to and delivery of healthcare, which we see in the COVID-19 context, and that the significant bioethical implications that has, which tend to be, in my view at least, often marginalized, certainly within patent practice, but also arguably within some mainstream patent scholarship. Primarily, I want to reflect on, or I suppose to question how we as a patent community engage with the nature and the role of patents and this marginalization of the broader bioethical and public policy implications of patents within the system, which I think at this point requires fundamental reconsideration. In terms of the nature and the role of patents within the broader health innovation system, as others have already alluded to, there is much discussion about the economic role of patents, patents being viewed and examined primarily as devices which can incentivize or encourage innovation. The effectiveness of patents' role in incentivizing health research is questionable in some contexts, and I know Luke has already mentioned some aspects of that, and it's highlighted within the COVID-19 context, but also in other areas. However, even if we leave that discussion aside in terms of the role of patents in incentivizing or not, or how they incentivize innovation, even if we leave that to one side, in my view, there's also another question that we have to ask around what other role patents has beyond that incentivization function. And in this respect, I mean patents' role as a private governance function, or as enabling private governance of technologies under patent for the duration of the patent. And particularly when the patent or the patented technology is a health technology, that needs to have much greater scrutiny, I think, within our discipline. Patents, in terms of their governance function, this is, whereby what I mean in this context when I refer to this is the exclusionary nature of the patent right and how that enables rights holders to control how the patented technology is developed and used after the patent is granted. And that includes allowing rights holders to dictate potentially who can access patented technologies for the duration of the patent and also on what terms these can be accessed. The appropriateness of that largely unfettered governance function of patents is particularly problematic, I think, in the health context, and has significant broader bioethical implications in terms of the effect that patents, and particularly how patents are used by the rights holders, on interests like human dignity, human autonomy, but also on the very fundamental issues of access to and equity in access to essential health technologies. And these issues have been demonstrated in the past by numerous examples, including starkly by the HIV/AIDS crisis. However, COVID-19 has also placed a significant spotlight on these issues again. And in this context, we have seen evidence of the potential implications that patents can have on the health treatment context at all stages, from diagnostics to medicines to the vaccine context. And I think it is worth reflecting on some of those stages. And in all of these contexts, it is a potential effect. I'm not suggesting patents always have a negative effect for access to healthcare, but much depends on how the patent holder chooses to use their particular patent. And this gives considerable discretion to the rights holder, which in my view requires further scrutiny. For example, the diagnostic context. In the early stages of the pandemic in 2020, we saw a legal challenge in the US taken by a company, Labrador Diagnostics, against BioFire, alleging patent infringement in the development of COVID-19 testing kits. Now, this was in the height of 2020 when we started the pandemic. The challenge received a considerable amount of public backlash, and amidst that, it was eventually dropped. But nonetheless, the example, I think, shows that even in the face of a mounting and really significant, probably the most significant global health crisis in our time, we see patents can be used as devices which can limit or at least constrain or potentially constrain how testing could be provided in that context. We've also seen examples in the medicine context around remdesivir, where the rights holder agreed to a considerable amount of the supplies of remdesivir going to the US in a context where that was at one point in time seen as being something that might be useful in terms of treating COVID-19. That's later been questioned, but again, it shows the gatekeeping role of rights holders within this context, even in an emergency crisis situation that we continue to face. And in the vaccine context, of course, which there is much discussion around currently, we have seen how many higher income countries have agreed bilateral deals with rights holders to obtain priority in terms of supplies of vaccines. And we've also seen the vast inequity now that has emerged and is, intensifying between those who have access in higher income nations primarily and those that don't, particularly within low and middle income countries. Meanwhile, we've also seen a lack of engagement by many of the rights holders with voluntary initiatives like the SciencesPo, which proposes sharing of intellectual property rights data, knowledge, know-how in order to increase production capacity for COVID-19 health technologies. And we've also seen instances with rights holders rebuffing attempts by others to collaborate to increase manufacturing capacity. And with all of these examples, what I'm trying to, I suppose, show is, and to call into question, and to ask our discipline to call more into question, the way in which patents enable rights holders to have this gatekeeping role over who, or in this case, what countries, I suppose, can access essential health technologies, even in a global health emergency. It's my view that we must question how patents can be used and how that can impact bioethical interests at stake. And indeed, there is scope, I believe, for such bioethical implications to be taken into account within the patent system, and also a recognition of this. We see examples of this under, for example, recital 16 of the European Biotech Directive, which suggests that patent law should be applied in a way that respects fundamental principles of dignity and the integrity of the person. We also see the morality provisions and other provisions that I'm happy to come back to. But generally, those provisions tend to be at grant stage interpreted in a very narrow, restrictive manner. And then after grant, there also tends to be limited engagement with the potential, or limited engagement with how the patent system should address the potential bioethical implications that patent use can have on access to and delivery of health technologies. And this all, in my view, warrants much greater questioning. Aside from the implications that patents have for health technologies, I will make just two further observations and final points on why it's my view at this point we really need to scrutinise patents' gatekeeping role over health technologies. First of all, there has been considerable change in terms of the technological landscape, when we think of, the development of the European Patent Convention in the 70s and on other patent legislation, there's been a vast change in terms of what the technology looked like then and what technologies look like now, and also a vast change, particularly in the health technology landscape, in terms of the emergence of biotechnologies and the advances that we've had in health technologies and the relationship between those technologies and the human body. And again, arguably that requires much greater scrutiny as a result of that. And also there's been a changing nature of the patent system, including, as Luke and others mentioned earlier, the adoption of the TRIPS agreement and the fact that now within TRIPS, WTO countries have to grant patents on all fields of technology. So, the technology is changing, the landscape is changing, and then we're also having less discretion for many states in such contexts, which is also, I think, problematic. And with all of this in mind, and I'll just end on this point, I do think there is a need for us within the patent discipline to take a step back and consider to what extent the current system is operating as it should be. Is it configured as it should be, particularly in the health context? And to reconsider that relationship and the conversation that we could or should be having with other disciplines, like within the bioethics context and the health context, to bring together understandings within both disciplines and to kind of go forward with a system that might take into account human dignity, interests like bodily integrity, and to acknowledge also the driving force that patents can have in enabling inequities within the healthcare context.
Thank you very much, Aisling. That was really informative and a tour de force of the relationship between IP law and bioethics and health law. So I'm really grateful for that. I'm always wondering to what degree IP law and the formalist IP lawyers are willing to think about other kind of legal values and normative systems as part of IP law system itself, or whether they think this is something which is a top up or an add-on. So that's something which I think is an interesting question to explore later on, perhaps. Thank you very much. And now I would like to invite Dr. Els Torreele to speak. And Els is a policy associate at the UCL Institute for Innovation and Public Purpose, where she has published several articles on the implication of the IP system on the current pandemic situation with Mariana Mazzucato. She has also worked over 2 decades at the interface of pharmaceutical R&D, human rights, and access to medicines, policy analysis and advocacy around biomedical innovation and access, for example, as the executive director of the Access to Medicines campaign of Médecins Sans Frontières, and also leading the Access to Medicines and innovation work at the Open Society Foundation. And I'm really pleased that Els is joining us for this event today. So I hand the mic to you, Els.
Oh, well, thank you so much, Hyo. And I mean, I'm very excited, and the more I hear, the more excited I am to be part of this, because I mean, some of what I have heard already, I mean, even though you can say it's quite dry and technical, but it rings like music in my ears, because a lot of the questions, and in particular the framing, Luke, that you brought, I mean, many of us have been saying and asking these questions for a long time, and yeah, now it's fantastic to know that's actually scholars, because I'm not an IP or a legal scholar at all, and if we say this of us, these things were very quickly dismissed. So the fact that there is a group of scholars that is increasingly getting into asking these questions about the basic assumptions, I think it's fantastic, and so much welcomed and happy to be here. I'm also going to make a few comments, maybe not all very well organized, also building on what I've heard, but maybe to start also, like as Graham did, with a little bit of background. So I am a biomedical researcher as a basis, a biotechnologist, and so I graduated in 1990 in Brussels, and I started doing my PhD in biomedical research, and it was exactly the time that in many European countries, following the US after the Bayh-Dole Act, etc., the idea was that universities, certainly in biotechnology, biomedical areas, should patent their research, because that was the only way to actually translate that into, or transform it into products. So I remember the time when we started to be asked to take out patents, and everyone, the scientists, we were extremely uncomfortable with that because it was not how we functioned, but that went then together to with confidentiality and because you couldn't publish or even present your findings at a conference before there was already a patent lawyer that had looked at it. Maybe it could be patented, etc. And it was a cultural shock somehow. And when I look now, 30 years later, young students in any of the areas of biomedical research, etc., they have all taken for granted that you have to take out patents, and that is the only way. And you are entitled, by the way, also that your intellectual whatever production, that you can appropriate that either on behalf of the university, but your name will be on the patent. And there is this kind of personal ownership. That it's a total cultural shift that I think we sometimes forget how little time, or maybe just 30 years ago, this was totally different. The idea that knowledge was shared, was there to be shared, that you better collaborate rather than go into secretive competitions. There has been an enormous, narrative change and behavioral change among the scientists. So I say that because I think we need to, two things. It was different before, and the level of medical innovation, I mean, we had many more antibiotics and anti-infective medicines then than we have now, by the way. So it was not that there was no medical innovation. Actually, the 80s and the 90s have been very productive. It was just not as profitable, because what we see is today we have an extremely profitable, extractive, financialized industry, but I'm not sure we have less medical innovation. So it was possible differently. And it's not so long ago. That's the first point that I wanted to make. And then, indeed, I mean, COVID-19, it's unbelievable. I mean, those of us that have been working in access for 20 years, like me, always thinking about how can we drive medical innovation in a way that access is part of it from the start and not something that you have to solve afterwards. I mean, we're baffled by suddenly all this attention around IP, and we've been working, I mean, since HIV, as I was saying, trying to move the target, but we've been on the losing end. I mean, since the TRIPS agreement, and okay, we had a little win with the Doha Declaration, with some recognition that yes, for health, but in practice, it hasn't worked. We have actually lost. I mean, medicines have become more and more expensive also in rich countries. Access problems are abound on any disease area now. I mean, and so it's fantastic that we see this interest. At the same time, I think it's a real opportunity because, as was already mentioned, there are so many assumptions that are taken for granted. And I want to raise one in particular. The idea that it's an incentive for medical innovation. Now, what is the purpose of medical innovation? It should be to improve health, people's health and health outcomes. Now, you're all IP scholars. Is there anything in, for instance, the patentability criteria that talk about medical outcomes? No, there is none. I mean, originally, and you know the history of intellectual property better than I, but it was never meant to promote health innovation. Kind of health has been captured into a system that was there to promote, product innovation of some sort and commercialization, but it's totally unfit for purpose for health. And I think that this is something that we need to really keep in mind, that to say, well, how do we deliver health innovation that addresses people's health needs and in a way that can improve their health outcomes? And then you create an innovation incentives policy context that is actually oriented towards that. But there is nothing in the patent law that is actually oriented to that. And I think that that's something really important to highlight. And then You can challenge it, how it works today, but we also need to come up with alternatives. Now, I don't think that monopolies, of course, I mean, knowledge and monopolies and knowledge sharing that we have, that we need for health, it doesn't go very well together. There is also the question of whether it needs to be commercial. Why in the health systems, can we invest in health in a way that is actually delivering health outcomes? And this is the work that you were referring to, that I'm now trying to do with Mariana Mazzucato. It's kind of, how can we think about creating in economic incentives that has as a purpose increasing health outcomes? That is not what the patent system and the incentives for innovation are about. By the way, there are generally no health people in the conversation. We all know that, I mean, WTO, trade ministers, they don't care about health. It's also not their mandate to care about health. But as already was said, the implications, the real world impact of patent monopolies and the gatekeeper consequence is a difference between life and death. And so, in a way, patents and intellectual property are exquisitely unfit for purpose if you think about health. So, of course, where we are now, I mean, it's this big wall of intellectual property rights everywhere. That now with COVID we have an opportunity, and I'm really counting on all of you to help debunk some of the myths and wrong assumptions or untested assumptions, such that we can finally have a real conversation. Because that has been, for me, the great thing about COVID. It's been the first time since long that we have a conversation in society, because everybody talks about it. I can have a conversation with my father today, who understands what I've been doing for 20 years, which before he didn't, in a way, understand, because everybody is talking about it. There are articles everywhere, and a lot of emphasis on the IP waiver. And maybe important to say that I don't think that many in the health area think that the IP waiver is the solution, but it has become the kind of rallying cry that opens up the doors to talk about all the things that are wrong with the current system. But if there is a temporary waiver on a number of technologies, I mean, we all know, certainly for the vaccines, we need technology transfer, we need capacity building, we need many other things that the waiver won't necessarily bring. But the waiver has been this kind of, it's not even a Trojan horse, it's been a conduit towards having finally the conversations that we have been unable to have about benefits and who gets the rewards, who does the investments, who does the actual innovation, and I mean, the BioNTech or Moderna and NIH, who did the innovation, and who is making the money, the Pfizers and the shareholders of these companies. I mean, all of that is currently on the table, and I think that is fantastic, and where we have for the first time, and I also want to acknowledge the whole thing about how this technical issue of IP